The Constitution of the United States, and more specifically the amendments which make up the Bill of Rights, are the foundation of our rights here in America. Every person who lives here should have at least a basic understanding of these rights, so let's talk about them. Hi, I'm John, and this is My Crazy World. Today we're going to discuss the Constitution of the United States. It's the supreme law of the land, and the people who live here should know what it says, as well as what it means. Before that, though, the disclaimers as usual. I'm not a constitutional law professor, nor a Supreme Court justice. This isn't legal advice, it's just for informational purposes. If you don't want a quick background on the Constitution and what led up to it, you can go to this timestamp below to get to the Bill of Rights portion. After declaring their independence on July 4th, 1776, Americans fought the Revolutionary War against England until the Treaty of Paris ended the war on September 3rd, 1783, although Congress didn't ratify this treaty and officially end the war until January 14th, 1784. Drafted in 1777, America had been using the Articles of Confederation since 1781 as the means to govern the country, and this continued after the Revolutionary War had ended. However, the Articles of Confederation didn't give the central government hardly any power. It could conduct foreign diplomacy, control the military to fight wars, and mediate disputes between the states, yet it couldn't collect taxes on its own and was dependent on money from the states in order to pay its operating costs, but the states could simply refuse to pay. Indeed, with the Revolutionary War won, many states did start refusing to pay the central government, and with any significant legislation requiring a positive vote from every state, each state had veto power over anything they didn't like. The Articles of Confederation were all but useless pieces of paper at this point, and the country was more a series of states with loose association to one another than an actual country working together. Clearly, something more robust was needed than the Articles of Confederation in order to have a worthwhile central government, a government that could help the country be functional and prosperous while being both supported and supportive. This led to what we now refer to as the Constitutional Convention, which took place in Philadelphia, Pennsylvania from May 25th through September 17th of 1787. Delegates from every state except Rhode Island arrived to participate. However, the stated purpose of the convention was to revise the Articles of Confederation, and that is what most representatives thought they were going to be working on. Many delegates would not have agreed to participate if they had known from the outset that they would be completely replacing the government as it currently was. James Madison and Alexander Hamilton had something else in mind, however. They wanted an entirely new framework for the government. As the convention progressed, many of the other representatives came to the realization that the Articles of Confederation were not worth trying to fix, and it would be best to start off with a new system altogether. What would be developed over the next several months was the Constitution. It was written with the goal to provide a central government which was strong enough to act on a national and international level, but without being able to violate the fundamental rights of the citizens. This balance was found by dividing the government's power into three separate branches, so no one branch or person had too much influence. The executive branch, headed by the president and vice president, who are elected by the people. The executive branch is supposed to enforce the law of the United States, spend money as allowed by Congress, declares states of emergency, and appoints judges to the Supreme Court when openings are available. The legislative branch, which is Congress, consisting of representatives elected by citizens from their local areas. It is made up of both the House of Representatives as well as the Senate. The legislative branch makes the laws of the United States, controls the money our government spends, and has the power to declare war. And then we have the judicial branch, which consists of the Supreme Court, with justices appointed by presidents and confirmed by Congress. The judicial branch interprets laws, with perhaps their most vital role being to judge when a law is unconstitutional. More on that later. After completion, the Constitution had to be ratified by at least 9 of the 13 colonies before it could go into effect. On June 22, 1788, New Hampshire became the 9th state to ratify the Constitution, and so on March 29th of 1789, the U.S. began operating under the rules of the Constitution. North Carolina, and once again Rhode Island, were the only states who still hadn't ratified the Constitution by the time it took effect. Most of us know the "We the People" portion of the preamble of the Constitution, but the entire statement is as follows. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. These words and the meaning behind them are quite powerful. They aren't there just to sound good, but were considered so vital to the purpose of the Constitution that James Monroe called the preamble the key to the Constitution. Going even further, Alexander Hamilton stated that the preamble negated the need to have a separate Bill of Rights. Others didn't feel the same, however, so on December 15, 1791, 10 amendments to the Constitution were made. These first 10 amendments are known as the Bill of Rights. Collectively, they spell out the rights and liberties of individuals, protect those rights from government violation, and states that any powers not specifically granted to the federal government instead belong to the people and the states. Most of the rights are direct responses to injustices the Founding Fathers saw with laws and treatment the colonies endured while under the rule of the British Empire. They sought to protect American citizens from those injustices forever. While the Constitution is the supreme law of the land in some regards, it is also an important distinction that it does not necessarily overrule other laws. Something that many people don't seem to understand is that just because a right is in the Constitution, if you use that right illegally, you are still committing a crime. For example, if you use your Second Amendment right to keep and bear arms to end someone else's life, you have still committed a murder, assuming it wasn't in self-defense or the defense of others. Likewise, you can't make the case that arson, battery, destruction of property, and theft are somehow covered by the First Amendment rights to free speech and right to assemble. Whatever you do, it still has to fall within the realm of being legal activity. As for the difference between rights and abilities, you have the ability in many countries to say things or practice various religions. However, in America, you have the right to do so. The difference is an ability can easily be taken away, like when anti-government protesters are arrested and imprisoned in foreign countries, or how in many countries certain religions are outright banned from being practiced. Another example is how firearm ownership in several countries has all but been abolished in recent decades. With that said, let's get into the actual amendments. The First Amendment states, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Put in first place for a reason, the First Amendment is likely our most important constitutional right. It covers freedom of religion, the ability to practice whichever religion you choose without the government interfering. Freedom of speech. People have the right to speak and be heard without government interference. However, there have been many cases heard by the Supreme Court which have attempted to provide a guide as to how to balance freedom of speech of individuals and parties with other important government and societal interests. Freedom of the press. Intended to keep the press free from government control, it was meant to keep the press free so they could serve the interest of the people instead of the government. This isn't going very well lately. Freedom of assembly and petition. The right of the people to gather and protest without the government limiting them. Note that the amendment clearly states the right of the people peaceably to assemble. There is a significant distinction between peaceable assembly versus riots, with numerous crimes being committed. Criminal activity is not protected by the Constitution. And lastly, freedom of association, which isn't spelled out in the First Amendment, but which the Supreme Court has ruled that other people are allowed to associate with each other without the government interfering. Easily the most contested part of the Bill of Rights, the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This amendment, more than any other, gets misconstrued and therefore sparks more heated debates than the rest. Without delving too deeply into the matter, let's try to add some context. Having just fought a war with England, who still controlled Canada and had relationships with numerous Indian tribes, America knew it still needed a military to protect itself. England had also tried to ban the colonials from possessing firearms just prior to the outbreak of war. Not having the ability to sustain a large standing army, the former soldiers and members of the population would be militia members. In case of war, they would supplement the army until the army could be expanded to wartime levels again. This was the state of affairs when the Constitution was written in 1787. The practice of having local militias stayed pretty constant up through the Civil War, with the armies of North and South both filling their ranks with militia members. After the war ended, militias largely went away as the U.S. Army was finally a rather large and permanent force. So if we don't rely on militias to the extent written about in the Second Amendment, is it even relevant now? Well, the simple answer is yes, as much as some people don't want to hear it. Constitutional scholars generally agree that the Second Amendment has two separate parts. The prefatory clause that states a well-regulated militia being necessary to the security of a free state, and the operative clause being the right of the people to keep and bear arms shall not be infringed. So even if you make the case that the militia doesn't exist, you're still ignoring the second part that grants the right to the people. The Supreme Court agrees. In the 2008 ruling on District of Columbia v. Heller, the Supreme Court concluded that the Second Amendment provides an individual right to keep and bear arms for lawful purposes. They thus deemed that the laws enacted by the District of Columbia inhibiting that right were unconstitutional. In fact, in recent years there have been numerous laws in various states that have been struck down as unconstitutional, even though citizens had to abide by these laws for decades. In the case of the Bruen decision in New York, the unconstitutional law was over a century old, going back to 1913. Moving on, the Third Amendment states, no soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This amendment may seem a bit odd for modern Americans, but put in the context of the time in which the Constitution was written, the British had recently passed the Quartering Act of 1765, which allowed them to take over buildings in America to house soldiers. The Third Amendment was a response to that injustice, which the Bill of Rights sought to prevent. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment is fairly simple to understand, but it provides some important protections that many Americans don't know how to utilize properly. In layman's terms, people and their belongings can't be searched or seized by the government or police unless a warrant is issued based on probable cause. That warrant then only allows the search or seizure of the people and or property that is specified within that warrant. So how do people screw up and lose the protections provided by the Fourth Amendment? Oftentimes during an encounter with police, they will consent to a search when the police officer asks them if they can look through their car, belongings, or house. Or police say they are going to conduct a search and people go along with it because they think they have no other choice. Once you give your consent for a search, a warrant is no longer required and your Fourth Amendment rights are temporarily gone. You can state at any point that you no longer consent, but police aren't always the best about stopping the search once they start. Also, by the time you do re-invoke your rights, they may have found enough evidence to support probable cause for a warrant or make an outright arrest. Bottom line, the people who don't consent to search and ask to see a warrant are the smart ones, even if they had nothing to hide to begin with. Most people understand the Fifth Amendment gives people the right to remain silent and not to incriminate themselves, but it covers much more. It states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." More than just a right to silence, the Fifth Amendment grants 5 rights and protections. The right to a jury trial, if you're charged with a crime, protection against double jeopardy, which is being prosecuted for the same crime multiple times, protection against self-incrimination, the right to a fair trial, and protection against having property taken by the government without fair compensation. The Sixth Amendment states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." To summarize, if you are accused of a crime, you have the right to a speedy and public trial, an impartial jury, to be informed of what the accused crime is, to face the witnesses against you as well as obtain witnesses to aid in your own defense, and the ability to have a lawyer to assist you in that defense. While most of us hope to never need the protections of the Sixth Amendment, it is of comfort to know that you do have such protections if you need them. Our justice system may not be perfect, but I'll take it over the many countries which have no such guaranteed rights to begin with. Ideally, we would have no one convicted of a crime that they didn't commit. I'd bet that thanks to the Sixth Amendment, however, we have more people on the streets that did commit crimes and got away with them than we have people in prison who didn't commit the crime that they are imprisoned for. The Seventh Amendment grants some of the rights from the Fifth and Sixth Amendments, but for civil trials instead of criminal trials. It says, "In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law." So it provides for a jury trial, like the Sixth Amendment, protection from double jeopardy, like the Fifth Amendment. Meant to further protect citizens from potential abuse by the legal system, the Eighth Amendment states, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." It is plainly worded amendment that gets to the point. However, it can be difficult to argue against subjective terms like excessive or cruel. Having the amendment keeps some restraint in the system, and if you feel it has been violated, you can sue to have your case heard. The Ninth Amendment only says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This is a fancy way of saying just because several rights were specifically mentioned in the Constitution, like free speech, right to keep and bear arms, right to a trial, etc., that it doesn't exclude other unnamed rights from being protected by the Constitution. While this leaves us with questions as to what other rights might be covered, The right to privacy and the right to marriage have been considered covered by the Ninth Amendment as well as many others. Additionally, this amendment works hand in hand with the 10th Amendment, which states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Basically, if the Constitution doesn't specifically grant that power to the federal government, then that power belongs either to the local governments or the people. This is why laws can vary so much between different states, and why our federal government can't just create laws for everything it can imagine. That concludes our review of the Constitution and the Bill of Rights, as well as how they came to be. If you enjoyed this or found it helpful, hit that like button and consider subscribing. Sources will be linked below. Thanks for watching, and I'll see you again soon.